All right, welcome back. Welcome back. Um, Questions before we get started. Good. All right. Uh, Before we start the next topic of zoning, I want to run through at least one more our cursed diagram, and I want to do this in rapid fire. And I'm going to ask you a question. In order for A to sue B, what has to be present? In order for A to sue C, what has to be present? I'm not asking. God bless you all. Yes, good, good, good. But I want to just call one at a time, people, and see if we just go through this quickly. Okay. All right. So who do I begin with? Who's next? Was that your first? Okay. So for Amy to sue Bob, I'm sorry. It's okay. It's okay. All right, Jose. For Amy to sue Bob, what must be present? Do they need horizontal privity? No. What can they sue on? They can sue the contract. Correct. Don't forget that. So yes, if they have horizontal privity, that's good. They don't need it. You next, Shrita? Okay. Or no, they should do you next. Yeah. Okay. You're next. In order for Amy to sue Carl, what must be present? Good. Correct. Okay. Sydney. In order for Diane to sue Bob, what must be present? I'm sorry? Okay. And what else? Does that have to be vertical privity? No. Daisy? For Diane to sue Bob, what must be present? So spell it out. So between Amy and Bob, what must be present? Okay. What about between Amy and Diane? What do you mean by just privity? You're very right. In other words, how would you describe it? A relationship, that's fine. There has to be some interest conveyed from Amy to Diane. It's not vertical privity, it's just privity. All right. Name Maria? Maria, I'm named that more or less in my head, right? Maria. For Diane to sue Carl, what must be present? Okay, just spell it one at a time. What has to exist between A and B? Correct. B and C? Correct. A and D? Some or all, some interest, privity. Good. Okay, you got them all right. All right. See, you got there. You didn't think you did this last week, but you got there, right? Good. I'm happy with that. Now, we also have what we call the mutually restrictive covenants, right? Where the benefits and burdens exist on both sides. Let me flip it. Julia, what has to happen for Carl to sue Amy? I'm just flipping it around. For Carl to sue Amy. Where do you always start? What do you always start with? Correct. Between A and B. Okay. What next? Between who and who? Do you need vertical privity for Carl to sue Amy? If Carl's filing the lawsuit, does he have the benefit or the burden here? Paula? So if Carl's filing the suit, Carl's the benefit, right? What has to happen if the benefits aren't to Carl? What do they need? Some type of interest, right? Do you need vertical privity for Carl to sue Amy, Paula? You tell me. Correct. You do not need vertical privity for Carl to sue Amy, right? Keep in mind, if I have a mutually restrictive covenant, it's the same rules, they just apply on the other side. For the benefits to run from Bob to Carl, you only need some privity, some relationship. What I told Daisy to say, right? You just need some interest. Oh, if you repeat what I say, you can't be wrong. It's actually no. It's a safe approach, right? Max.
So you asked if you need vertical privity for C to A,
Correct.
but don't you need horizontal privity and then vertical privity between B and C?
No, you do not. I just explained why you don't. In order for C to file the lawsuit, what must C have?
A benefit.
In order for the benefit to run, do you need vertical privity? No, you do not. What do you need?
That's where I'm lost.
Paula, tell him. Daisy, tell him.
I just said that the benefit.
But for the benefit to run, you need some kind of interest. How do you define vertical privity, Max? What's vertical privity?
I would say vertical privity is like the transfer of interest from
How much of the interest?
all of it.
All of it. For the benefit to run, do you need to transfer all of it?
Yeah.
No. No, you do not. For the burden to run, you must transfer the entirety. For the benefit to run, you can transfer any interest.
So it doesn't have. Okay.
Yeah. All right, I want to see that. All right, so Caitlin, you're up next. What has to happen for Carl to sue Diane in our diagram? Carl to Diane with a mutually restrictive covenant. Between, okay. Do you need vertical privity for Carl to sue Diane? Okay, what between Amy and Diane? How will Diane be subject to the burden? In order for Diane to be sued, what must she have? Not just any interest. Why? No. What in order to be sued, you must have the burden, right? What's needed for the burden to run from Amy to Diane? What do you need to have? Correct. So say it again. So one more time, Caitlin. For Carl to sue Diane, what must be present? Three things. Correct. Correct. You got it. Everyone see that? It's the mirror image of Diane suing Carl. Right? I asked you 2 minutes ago. I forgot who it was in the second row for Diane to sue Carl. It's exactly the same mirror image. For Carl to sue Diane with a mutually restrictive covenant, you have to have horizontal privity between A and B. You need to have some privity between Bob and Carl. And there must be vertical privity between Amy and Diane. All three must be present.
So just to be clear, there's only going to be one side that has burden and one side.
But they both, in the same diagram, I just asked you the same two questions. Both sides have the benefit and both sides have the burden. That is the definition of a mutually restrictive covenant, like in a subdivision. Both sides have the benefit, both sides have the burden. Everyone get those? I'm so sorry. You're right behind me. I apologize, Alexa.
So with that example, A and B have to have privity to where all the interests are conveyed or just any?
Well, for the burden to run from A to D, there must be vertical privity. What must be transferred to have vertical privity?
Any interest?
No.
No, all?
Which one is it?
All interest?
All. For there to be vertical privity, A must give her entire interest to Diane. Right?
So what's the difference between that and the privity when they only get one?
Daisy, what's the difference between that, between vertical privity and other privity? All of it. And what's regular privity? Some. Right? I mean, this is why I don't like the word privity. It's sort of confusing. But when you're talking about the benefit transferring, you need just some interest. It could be a life estate. It could be a term of years. Right? It could be a fee simple determinable. Whatever it is. Right? That's enough for the benefit to run. But in order for the burden to run, A must give whatever she has to D. Make sense? Questions? I'm sorry. Also behind me. Yes.
Last class, I wrote down that, yes. So
I'm sorry. Say again.
It was no need for horizontal privity for C to suit A because the benefit is still.
Correct. Correct. You don't need horizontal privity if you under theory of contract. Right? Let me repeat what you said. Maybe you didn't hear her. Carl could sue Amy, right, under theory of contract, even if there's no horizontal privity. Right? Even if there's no horizontal privity, Carl could sue Amy under theory of contract law because the benefit is simply assigned to Carl from Bob. Lex, does that make sense? I'm sorry, Lex, does that make sense?
Yes, I just wanted to make sure because you were saying you don't need vertical privity for
the benefit to run.
Okay, but you need for the burden.
Correct. Everyone get all those different combinations, right? If you want to just go over this weekend, just run through A sue B, A sue C, D sue B, D sue C, B sue A, B sue D, C through D, right? Go through each of those permutations, right? And figure out what's present for each of those. If you can do that cold, you've got this topic down. If you can't, go watch a video again. Good? Have I beaten this one to death? Yeah, a couple of you put in your little minute comment that you want to review, so I wanted to start class up on that note. See, diagram's not so bad. It gets better as you suffer, unfortunately. All right. We go on? All right. Our next topic is zoning. Right? Our next topic is zoning. And really, the rest of this class, I hate to say, is con law. So if you like con law, good. If you did not enjoy con law, well, you have me now, right? Sorry, that was bad. But truly, the second half of the semester is almost entirely constitutional law. In fact, I really think we should even teach this in property too. You ask me, I would make property a 4-hour class and cut out this entire topic and put in con law. That's what I would do because there's almost no property law here, right? There's almost none. It's just constitutional law. So I don't like it, but I will do my best to teach it. All right, so let's start off with a question. Short answer. This is almost as bad as was public policy. What is the police power? Let's just give you that question to begin with. Come on. Thing is spinning. It's going to crash me, isn't it? Oh boy. All right. This one's not going to work today. Who's next? Caleb, what is the police power? All right. It's the power of the state to regulate the health, safety, welfare, and morals of the people. Caleb, where does this power come from? Did the states not have a police power before the ratification of the 10th Amendment? Anyone want to take a guess? Keep in mind, I'm sure you learned this from your common law class, but the Constitution was ratified in 1789. Bill of Rights ratified in 1791. We had a good 2-year period without a Bill of Rights, so the answer cannot be the 10th Amendment. 10th Amendment's overrated. It sort of declares what already is. Does anyone know where the police power comes from? Ivan? No, I just said it's not the 10th Amendment. I think he's wanting to say it's not the 10th Amendment. Oh my goodness. Ivan. Common law public policy, Caitlin? Well, who's the sovereign in our republic? The government, the people, the states. That's actually better. I like the guarantee clause. It's an underrated provision. Much more than the 10th Amendment, actually. Okay. Yeah.
Sovereignty start with the division between what a country, nation, and state is, because the United States is a state on the international level. They're recognized by their sovereignty on. We're talking about the sovereignty aspect. I'll get into system.
Randall, what does sovereignty mean? We use this word and don't really think about it. What's sovereignty?
Sovereignty is the right of the state to dictate certain things.
Dictate. Oh man, that's heavy. That's heavy. Govern, maybe? Govern?
Govern.
Okay.
The ability to control different
All right.
aspects. Or different-
Lloyd, then, yeah, Alex. Go ahead. 1, 2.
I was just gonna add on there, for a state to govern itself.
State to govern itself. Okay. Go for it. Social contract. What's that? Whoa. You say whoa? Yeah, whoa. I agreed. You didn't agree to it?
I did not.
You didn't opt in?
Well,
You click, you accept the terms of service on iTunes, didn't you? You didn't read the terms of service? Lock was in there. It was in there. Every time you update your iPhone, you agree to lock. No. All right. So this is a question which at least I begin with con law. So the first day when I teach con law, I have the students read 3 documents. They read the Declaration of Independence, start to finish. They read the Articles of Confederation, start to finish, and the U.S. Constitution, start to finish. I do all 3 documents in one class. It's intense. But I start to finish every clause. And if you think about the Declaration of Independence, which I'm sure you all read, I'm sure you have close to your hearts, right over here, right? It comes in handy. Think about what the Declaration did, right? We had the king, right? The monarch, where all power was derived from the king, and perhaps Parliament later in the British Empire. And at a certain point, the colonies said, "Adios, we don't want you anymore. We're declaring independence." So the sovereignty didn't just sort of vanish. It has to reside somewhere. Right? Where did it go? Well, if you read the Declaration, you start off with colonies, and you wind up with states. And whatever police power or whatever sovereignty the king had, the monarchy had, devolved to the 13 states. And those states spent some time fighting a war. And they had their own governments. And during the Revolutionary War, states had governments. They enacted laws. They regulated property. They did things to people. And then time went on, and in the early 1780s, depending when you count, we ratified a system of government. It was the Articles of Confederation. And the Articles of Confederation delegated some power to this new central government. Not a lot of power. In fact, not nearly enough power. That was the failing of the Articles, right? So the states gave up some of their sovereignty to this new central government to try and form a union, confederacy, if you will. And that quickly proved to be not very successful. So a new government was formed under the Constitution. And indeed, it was the people, or at least most of the people, or some of the people, who ratified that document. And through the Constitution, the states surrendered more power to this new government. You know, our favorite Commerce Clause. You ever think about it? The Commerce Clause says, okay, the states will not regulate interstate commerce, the Congress will. The states will not declare war, Congress will. The states will not receive ambassadors and other foreign policy decisions, Congress will. Right? That was a surrender of authority. Right? So the states gave up some of their executive powers, some of their police power to this new central government. But they didn't give up all of their police power. Right? Because Maria, what does the 10th Amendment say? You said it. Right. So the powers that are not delegated to the federal government are reserved to the states or to the people. Right? That's what the 10th Amendment says. That's there. Right? So the 10th Amendment simply reflects what happened before. The states had this huge body of power which came after independence. Some of those powers were given to the central government. Everything else was kept by the states and the people themselves, right? What was retained by the states? The police power. The states surrendered some of their powers over commerce and war and things of that nature, but they kept everything else, and that's the police power, which is defined broadly as, I think someone said a few minutes ago, Kayla said a few minutes ago, the power to regulate the health, the safety, the welfare. She added morals. I don't know if I put morals in that. That's kind of more modern conception. Morals didn't usually fit in there, but sure, morals, why not? Right? Of the people. Does the federal government have a police power? No, they do not. Under most interpretations, federal government powers are enumerated. That is, they're limited to those listed mostly in Article 1, Section 8. Sound familiar? It should. Right? But the states do have this residual power, this police power, to enact things like zoning codes, to enact family law, right? There's some areas that just are beyond the scope of federal power. Property is one of them, zoning is one of them, family law is one of them, and maybe a few others, right? So who has the police power? Police power belongs to the state. Right now, what is state government? You might maybe think, maybe you've been to Austin. Been to Austin, right? Been to the state capitol, this gorgeous building, this huge rotunda. You can lie down, just on the star. You've done that? Start lie down the star in the middle. My kids love doing that, right? What's that? Went to the tippy top?
Yeah.
Good for you, right? It is cool. So what is the relationship then between the Texas state government and this lovely city of Houston that we live in, right? What is Houston? Why is there a Houston? Why does it exist? You don't really study, maybe you will if you take Professor Rhodes' class. There's also state constitutional law, right? Every state has a constitution. My God, the Texas Constitution is long. It's got hundreds of articles. It's, the pocket one should fit in my pocket right here, right? Texas Constitution will not fit in my pocket. But state common law explains that there's different levels of government. You have the state, you have the county, you have the city, you have towns, you have even Texas villages, whatever the heck are villages, right? You have all these different subdivisions. These subdivisions exist only because the state gave them this power, right? There's a charter, the Charter of Houston, right? The state of Texas created Houston, and they gave it certain powers to govern, right? They created the city of Dallas, and they gave it certain powers to govern. They delegated to the city the power to regulate land and even enact zoning codes, which they may choose or choose not to exercise. If the good people in Austin, for example, want to abolish the city of Austin, they probably could do that. They could probably want to, right? But the Texas legislature says, "Yep, all right, Austin, you're not a state anymore. You're federal. You're an enclave of the state government. Goodbye." It'll make people unhappy, but Austin doesn't have to exist to get the District of Columbia, just so the sort of surrogate for the state government. Okay, why am I giving this huge wind-up? Because almost every question I'll ask you between now and the end of the semester is this: is this regulation, is this zoning ordinance within the state's power, right? If it is within the state's power, the state police power, they can do it. If this regulation is not within the state police power, we have problems, right? So if you hated the first half of common law but asking, is this within the federal power? Welcome back, right? It's the exact same question, just a little bit different. Fortunately, it's a little bit easier, right? We're not trying to figure out what the meaning of commerce is and the meaning of necessary and proper. We have statutes, right? We have rules that govern the scope of the state's power and the power of local municipalities. All right, we'll get that bit of a wind up. Sorry, I have to give a little rant at the beginning, but that's just assume you know. I assume you know nothing, and then I start bringing up to speed what I want you to be. That's how I usually run class. It's usually a good decision. All right, so let's try question number 2. If I get my clicky thing to work today. Oh, it works. Good. All right, so this is a true or false question. The government can deprive you of the value in your. The government can deprive you of the value in your property without providing just compensation. True or false? No. Answer the question, then I'll talk. I think Grayson is up next. Another 15 seconds. We're missing a K. Where's Katarina not here? Okay. I don't know if you know, but in baseball, a strikeout, the insignia is a K, right? So in the olden days, they would put a K on the scoreboard for each strikeout, and they would usually the third K they would just flip to avoid the obvious, right? They would just put the K backwards. Okay. Grayson, what's your answer here? Okay, why'd you put false?
I put false just because it seems very much against the Constitution to just take it without unjust compensation.
I don't see the word take there. I didn't
Or
put the word.
deprive the value of
Ooh,
your property.
ooh, you're smart, and you tried to anticipate my next question, didn't you? So let's see. Wow, that's pretty. That's about as close as it gets in this class. So let's look at the question I framed it. I framed this question very delicately and deliberately, and let's see if it works. Maybe not. I asked, the government can deprive you of the value in your property without providing just compensation. Now, Grayson anticipated what I was getting at, right? He said the word take, T-A-K-E, but that word doesn't actually appear in my question, right? But he's anticipating where I'm going with this. All I said is deprive you of the value of your property. Think of the case today, Village of Euclid. Did the government deprive the owners of that land of the value of their property? Oh, yeah, they did. Did they have to pay compensation? Oh, no, they did not. So how can it be? Right? Let's go to the Fifth Amendment. I'm sure if your Constitution's handy, I'll have it here if you don't. Right? Nor shall private property be taken for public use without compensation. The text seems to say, we can argue about it, that if the government takes your land for public use, they must provide some sort of compensation. There's that word, take, taken, T-A-K-E, take. Is depriving you of the value of your property a taking? Maybe. Yes, maybe no. The Supreme Court's case law in this area is a complete mess. You're going to hate me in about a week or two. This case is easy. This case is a piece of cake, right? The tests to determine if there's a taking are just completely incomprehensible. It's one of my least favorite topics of teaching because I hate it, right? It's getting a little bit better, but it's still hard to teach. But there are many cases in which the government can deprive you of the value of your property without paying up. And how do they do that? And the answer is question number one, which is the police power, right? If the government is going to regulate your property pursuant to the police power, it is almost always not a taking. You see, I sort of hedged there. Let me say it again, right? If the government is going to deprive you of the value of your property through the police power, it is almost always not going to be a taking. I will not make a 100% statement in this class because this topic is a mess, but as a good rule of thumb, you can rely on. Take this to the bank, right? If the government uses a police power and that happens to diminish the value of your property, you're not getting paid. You're not getting compensation. So often in this class, we have to draw a line. Are we looking at an exercise of the police power, number one, or is this number two, a taking? If it's on the taking side of the line, then pursuant to the Fifth Amendment, right, compensation. If you're on the police power side of the line, no compensation. So what ends up happening in every case? The homeowner's like, you're taking my property, you're regulating my property. Pay me, pay me, pay me, right? And the government says, oh no, we're not taking your property. We're just exercising our police power from King George III himself, right? That's where he got it from. We're still exercising it. And the courts have to decide which side of the ledger is it on. Is it a taking or is it a police power exercise? The tests to determine if something's a taking or not, again, are a disaster. Just look at the readings ahead. Penn Central, my God, I hate my least favorite cases in Supreme Court history. Penn Central. So it's got to be my bottom five of worst Supreme Court cases hate to teach. Not that good or bad, just to teach it. I hate teaching that case. But we have to decide which part of the line we're on. All right, what's me so far, Ben?
This might be jumping the gun a little bit. So eminent domain is not a police quantity.
If you are actually engaging in eminent domain, the government's literally taking your property, right? They're going to bulldoze it, right? The way I describe it, we'll do this later. If a bulldozer is involved, there's a taking. Right? They're literally going to knock over your house. You're taking your house, right? That's an easy rule of thumb. If they're going to destroy your house with a bulldozer, it's a taking. If they enact a zoning ordinance that diminishes the value of your property, no bulldozers are needed, right? You get to keep your land, just you can't use it in the way you want. We will do eminent domain maybe in a week or two. I can't remember. Okay. Questions? All right. So just I want to just do a little more con law. I'm sorry. I'm sure you all learned about the incorporation doctrine. Fun fact: the Supreme Court never actually incorporated the takings clause. It's been deemed incorporated, and I'll just explain why. We often say today that the provisions of the Bill of Rights have been incorporated into the 14th Amendment. That is, the word liberty in the 14th Amendment embraces the Bill of Rights, and almost everything in the Bill of Rights have been incorporated, exception of unanimous jury and maybe one or two others, right? But there's no actual decision the court saying we're going to incorporate the takings clause. Instead, you have a case called Chicago and Burlington Railroad versus Quincy. That's Quincy. It's in my con law book, where the court said that it would violate due process to take property without compensation. I said it again. The court said it would violate due process to take property without compensation. That's not the same thing as saying the due process clause incorporates the takings clause. Justice Harlan had a very different view of incorporation than we would today. Anyway, but as a practical matter, the Fifth Amendment applies equally today, both the federal government and the state government. So if there's a taking by the feds, they got to pay. If there's a taking by the state governments, they got to pay. As an originalist matter, probably not correct, but we'll just leave that aside for another semester. Ivan?
If the government does take your property,
Which government? Say state.
the state government
Good.
takes your property through eminent domain, and they give you just compensation, and they end up not using your property, what happens?
You don't get it back. It stays with the government. Indeed, we'll do a case this semester called Kelo v. City of New London. It was this very protracted fight to take Suzette Kelo's little pink house in Connecticut by the water. I visited there. I told you I almost got arrested, right? The land's still empty. 10 years later, no, 2005, 18 years later, the land's still empty. They never built anything on it. It's completely empty. There are feral cats living there. Very nice for them.
Would that not go against taking it for the public purpose? Then?
Well, we will discuss what it means to have public use. And you said public purpose. You already said. The Supreme Court actually reads public use to mean public purpose. So you're reading it like Justice Stevens read it. Justice Stevens said public use and public purpose mean the same thing. It's not what the text says. No one else? Working for the bargain for, yes. Jose, is your hand up or just scratching? That's okay. That's okay. All right, so let's go on to the case today. Village of Euclid, the Ambler. It's perhaps the most perfectly named case ever. It's called an apt name. We're going to use that phrase, right? Because Euclid, if you remember from geometry, maybe not, was the father of modern geometry, of Euclidean geometry, planes, measurements. Perfect name. In the late 1800s, we start having a new problem, right? People no longer need to live inside cities. You now had modes of transportation allow people to live further away in suburbs, and they could commute, right? So with this problem, you know, had the development of a parasite, we're told, which was the apartment building, right? Where you would have lots of people living in a very small place. People with houses didn't like the apartment, thought that was encroachment on their sort of leisurely, calm way of life. So how do you handle the problem of an apartment building? Well, you could use nuisance and say that, you know, apartment buildings are out of place and they can constitute a nuisance with noise and smell and everything else, right? But nuisance suits are expensive and they're hard to litigate. So around the same time, the idea came around to have zoning. The idea was certain neighborhoods would be restricted to certain uses. For example, this area would be only one family residential. And what does that mean? No apartment buildings. right? That neighborhood would be, zoned for landfills. Okay, that we don't want us to live there, right? So you would basically slice up a community to different types of uses. And that way you would not need to rely on a nuisance suit, right? You could just say, here's what the rules are, and you cannot build here in the first place. But these zoning codes were considered very controversial at the time. Indeed, it wasn't clear if they were valid. Why? Think back to your common law cases from the early 1900s, so-called Lochner era. By the way, Lochner was probably not that bad. If you had someone else, oh, the worst thing in the world, it wasn't that bad. I'm with Harlan. It was probably wrongly decided. It wasn't that bad. Okay, but the court was very protective of property rights, and the court was very protective of economic rights. Zoning, as we see in this case, would often diminish the value of people's property substantially. So there's a lot of litigation that was bubbling up. And some courts actually held that zoning violates the takings clause, that the government wants to tell you how to use your property, they got to pay you for it. And if the government wants to slash the value of your property in half, they got to pay you for it. So Village of Euclid gets to the Supreme Court, and there's a little note about this after the case, and it's not all clear that there are votes to uphold it. Then we get the opinion by Chief Justice Taft, who was formerly the president, right, upholding it. By the way, Taft was formerly a judge on the Court of Appeals in Cincinnati, and if you ever go there, his chair is still there. Now, Taft was a big dude. He was huge, and his chair is like this huge, it's like a tree log. It's just this huge chair. And there's a story which might not be true, but I've heard it, is that he once rode on a horse's back and broke the horse's ankles. And then in response, people sent him a camel, telling him to ride that instead. He was a big guy. But he was a very important jurist. He never wants to be president. He always wants to be a judge. It's a read his biography, fascinating story. He really wants to be a judge and not want to be president. And so got bumped into it. So don't break any horse's ankles. Poor horse. I just feel bad for the horse. It wasn't his fault, right? All right. So the city of Euclid enacted a fairly typical zoning scheme. So if you have the diagrams in the case summary I gave you, or we can look on the board over here. If I want to just sort of walk you through this, okay? This works, okay. So there are three types of districts. Districts based on use, districts based on height, and then districts based on area, right? There are three types of districts. So every single basically inch of the town was restricted either with regard to what can be built there, the type of use, the height, that's how tall could things be, or square footage, the area of the lot. The most complicated one are the use districts. Okay. There's U1, U2, I guess like the band, right? U3, use guys, no, U4, New York is the thing. U5. Oh, I have a typo. Look at that. Look what Josh did. I doubled up U3 over there. No one even noticed. Anyone notice that? You noticed? You tell me. No, if you find me catching a mistake, you got to tell me because I got to publish this. This is a mistake. Oh man, I got to fix that later. All right, I'll fix it later. You did? Always go over the guy's head. That's how you do it. Anyway, U4, U5, and U6. Right? Think of it kind of like these overlapping areas. In the area zoned U1, you can only build, I'll start down here. In the area zoned as U1, you can only build one family residential houses. That's all you can build there. You can't build anything else. Now, you might not be very surprised to know that much of the town was zoned as U1 because they want to promote one family houses. Why? Well, they tend to be wealthier, right? People who want a one family house usually have more money. There's not much getting around that fact. people who don't have as much money may need to live in an apartment building or a two-family home. That's just a simple fact of life. So by zoning huge chunks of the residential area as U1, you are effectively excluding people with less money. And that's not a bug, that's a feature, right? One of the core aspects of modern zoning law is to keep property values high, right? This is not like a secret. They say this in court, right? We zone to keep property values high. Why? Well, if you have more property value, you have higher property taxes and more money goes to the government, more for schools and so on and so on, right? But the necessary consequence of limiting to U1 is poor people can't live there. And again, that's a feature, not a bug. All right, so in the U1 area, it's only one family houses. Okay. What about in the U2 area? In the U2 area, you have a choice, right? You can have single family homes or two family homes, right? You can always build less, right? You can always go down the row. In U2, you can have a one family home or a two family home. But I am willing to guess that people who want to build a one family home will not build in that area. They'll limit it to U1 to avoid having to have lots of neighbors, right? You generally only build in the best place for your lot. And the U2 zoning area would not allow, or would probably not have many single family homes. Everyone with me? All right. So then we go to our next zone, which I screwed up the labeling. This should be U3. Oh, this one so far is correct. U3. In the U3 area, you have a choice. You can build a apartment building. You can have the two-family home, or you can have one family home. I am very confident that in any one of these sort of wealthy suburbs, you will not have U3 zone areas. Or if they are, they're going to be so small you can't build anything there. Right? We'll do a case later this year about whether the government has an obligation to zone land for affordable housing. It's called Mount Laurel from our good friends in New Jersey. You know what they're going to do there, right? There's no mystery what they're going to do there, right? They're going to make something up, right? But in the U3 area, at least in theory, you can have an apartment building. There's not going to be much U3 in Village of Euclid. And you're not going to have many one-family homes living next to an apartment building. Not going to happen. This is where Josh screwed up. I put U3 twice. I'm sorry. But in U4, you have introduction of commercial, right? Commercial stores and the like. If you want to have residential in the same place as commercial, you probably can. But at least in reality, in modern times, you can't, right? Usually zones that are zoned residential can have commercial, and zones that are zoned commercial can have residential. That's usually how it works. Houston's unique that you can have like a department store with a house right next to it, right? That's very unique because we don't have a zoning code, right? The gallery is it's like a teaching area, right? Because you have stuff that's just everywhere. My house is adjacent to a Chick-fil-A. It's amazing, right? But that couldn't exist in any other city. Not quite. I mean, it's across the street, but it's close enough. It was really bad when I first moved in. He had Chick-fil-A 4 days in a row, and they couldn't eat again for a long time. It was so convenient. It's like right there. You have your front packs. I was at Chick-fil-A again, but it was bad. Was that question about Chick-fil-A? No. Sorry, I saw your hand go up. And there's a Panera at the other side, so it's very close. It's very nice. Okay. What else? U4 again is going to be some commercial mixed with residential. Then we go up the ladder. U5 incorporates things like factories and manufacturing, industrial purposes. So again, if you want to build a one-family house next to a factory, good for you. Not going to happen. So usually in these sorts of towns, there's going to be lots of U4. People like stores, but there's not going to be a lot of U5 because who wants a factory in their town? No, factories are good for jobs. Well, they're also loud and smelly. Build it somewhere else, right? Ben? No. In fact, they're so simplified. This is like from the 1920s. They don't look like this anymore, but it's a good sort of way to get your feet wet to sort of introduce you to the topic. This one's a very easy one to understand. I can put these in very pretty pictures, diagrams, which I made wrong. No one told me. But seriously, if there are mistakes, you tell me because I have to this is going to be published eventually, and I want to make sure it's good for students. How do you use the hand?
Oh, I was just gonna say, I printed them out this morning and there were no letters. Did you add them later?
No, where you got? Oh no, they're there on the computer. I don't know why they're not showing on your screen. I'm sorry. No, these diagrams have not changed since last year. Okay, I'm sorry, Patty. All right, and we do one more. We have the spooky graveyard. So in U6, you can have undesirable uses, which is like, waste dumps, garbage dumps, where all the stuff from Ohio is coming, apparently, right? Prisons, cemeteries, and the like. Yeah, we'll talk about that. Right. Okay. Yeah, Randall. I said U5. I said factors in U5. U6 is the undesirable stuff, like the garbage dumps and the cemeteries. Right? I get that one right. Yeah. Okay. Everybody get the overlapping circles, how that works. Okay, so I'll just jump ahead. I'll come back to the height and use districts later, but go down to our friends in Euclid. This is a residential lot bordering between a railroad and a commercial street. And they put some of it as two-family houses. Some of it is like apartments, and some of it is unusable. Yes.
There's a graveyard, and obviously you can't move a graveyard. Do you just build around it if it's in the zone that can't have?
Right. So there's something called grandfathering, right? Where something existed before the zoning code came into effect, it can stay there unless there's some substantial changes to it, which does occur. So if there's an old graveyard, you don't have to dig up all the graves, right? You can leave it there. But there are cases like, let's say that there was an old garbage dump in a city area and it was grandfathered in. You can keep it there unless they sort of change it. And we'll do a case like that later. Go ahead. Yes, sir.
Is there anything you can't build on U6s, or is it just anarchy?
But look, no, I mean, look, you're still subject to nuisance law, right? You're still subject to environmental laws, right? You can't build like a nuclear reactor without permitting. There might also be certain kinds of ordinances about what kind of business you can run. I'll just give you an example I had when I was clerking many years ago. This was in Western Pennsylvania before people knew about it. A group wanted to open a methadone clinic, right? What's a methadone clinic? Used to treat opiate addictions. This was before it blew up. People started seeing it was coming, especially in the Western Pennsylvania, Ohio region. It was very bad. And so they found a place downtown to open a methadone clinic. And the city modified the zoning code to exclude methadone clinics from the downtown area. Okay. So then they found a place out in, I won't say suburbs, but far away enough from town that it was sort of the U6 area, right? There was nothing there. And they were about to open up their clinic to treat these people with drug addiction. What did the city do? This was a genius move. There was a strip of grass in front of the clinic, and they designated that strip of grass a public park. And they said you can't have a methadone clinic within 500 feet of a park. Yeah, I remember that case. And I think ultimately the court ruled against it, saying, look, you guys are just playing, right? You can't make up rules as you go along to try to exclude this one business from operating a lawful profession, right? Because think about it, they didn't want to have people with drug addictions standing in the downtown area. Okay, maybe yes, maybe no, right? It's convenient for them, but then putting out in the hinterlands with no one's there, you still don't want them. Then that maybe goes too far. But my point is, cities when they want to keep something out get real creative. That they do this, they get real creative.
So some of this seems to be like against the city's financial interest.
Yes.
Especially in the
Yes.
space. But maybe we'll talk about that.
Yeah. No, it's true. I mean, let me put it this way. I hate zoning. I'm in the right city, I suppose. I'm an outlier. If anyone else for property, zoning is amazing. It keeps everyone safe and quiet, right? They're making very poor predictive judgments about economic consequences, right? If you actually look at it, zoning doesn't actually help the economy, it hurts it. It doesn't actually help housing, it hurts it. There's more downsides than upsides, but maybe I'm an outlier. I can disclose that. I like driving around Houston, like, oh look, there's a garbage dump right there. There's a house. Yeah. Randall, then live. Right. So federal is sort of a wrinkle, right? So generally, you say the guarantee clause, 10th Amendment, let's do supremacy clause, right? The supremacy clause means the federal government can't be controlled by the states, but they have to have land in the state. So often what happens is they will cede land to the federal government and they say you do whatever you want. But still you have cases where, if there's a federal courthouse downtown, the county health inspector comes by to check out their cafeteria. So it's a kind of a weird overlapping. I remember I had one case where they were selling alcohol on a military base and they had to get a state ABC permit, an alcohol beverage permit. So they have to still sometimes comply with the locals have to live. Right. So the assumption is if you restrict usage to a certain type, right, it will keep property values up. But that ignores that sometimes having mixed development, residential near commercial actually generates even more revenue. More people live there. So take Ashby High Rise for an example, right? That would have mixed wealthy people living near a wealthy shop. They've actually generated more revenue for the community than having only a couple smaller apartment buildings. So on balance, you can have more value by having mixed use. And there's a note on this in your book. I think Minnesota and some other jurisdictions actually are limiting their zoning codes to allow more mixed use to actually generate more revenue. But this idea that we have all U1 everywhere seems great, but actually doesn't actually help economically. Yeah, read the note. I mean, again, zoning historically has been very popular, but in recent years, even people on both sides seeing it's not all it's cut out to be. Again, I'm an outlier. Lochner was right. Zoning's bad. You'll get a different perspective in other class. I should at least be candid. I don't think Lochner was right. I think that Harlan's stent was right. Holmes is not right. No, don't get me started on Holmes. Most overrated justice after John Marshall. I could say that. True. Very overrated. All right, who wants to give me the facts? Save us. Who's next? Lisa, you've been waiting for like half an hour, haven't you? I'm sorry. I'm so sorry. Go. I'll come back in a bit. I'm sorry. I'm sorry. Okay, go. I feel bad. I don't want you to have a. All right, give me the facts and. Okay, I won't tell anything else. I'm sorry. Hmm? Hmm?
Ambler.
Good.
But as it's currently zoned,
Hmm.
it's only like 100 or it's just substantially lower than what they would be making for Euclid.
Right. Very good. Okay, you're off the clock. You're good. And Liv, this actually answers your question a little bit. If my notes are correct, if it's used for residential purpose, each acre costs $2,500, and if it's used for industrial, $10,000 per acre. Right. So I mean, restricting somewhat arbitrarily where you put different types of uses will invariably not use land to its highest value. The other issue I want to discuss is the areas, right? This chart. Most zoning codes require that you devote a certain number of square feet to building something. What does that mean? Things are spread out more, right? The more square feet you need for a property, the fewer actual properties you can put in an area. That's just sort of common sense, right? So if you have things spread out very far, you have very few actual houses, very few actual people living there, and that's less property taxes. Now the upshot is you have space between you and your neighbor, and space is perhaps nice, right? Tall fences make good neighbors, as they say. But you have things that maybe are a sprawl, right? Houston, hello, right? Houston has no zoning code, but we do have minimum lot sizes. That's actually been one of the huge issues in Houston. The reason why there's so much space between properties is you have minimum lot size, right? Houston also requires a number of feet in front of your house, what's called frontage. That's why many places in Houston have no sidewalks because there's not enough space, right? The streets have to be wide. The houses have to be wide. You just rub out the sidewalks. That's why in Houston you can't walk. I remember my parents first came here. They stayed at a hotel in the Galleria, and they wanted to cross Westheimer. I'm like, Dad, don't do it. Don't just don't do it. You're never gonna make it. And they had to run across the street. It's not a good idea. But you ever wonder why, right? Houston has. Okay, let me just pause here and mention. So Houston has zoning, but it's not the way we think of in other places. We do not have in Houston use districts. Like you can have a waste dump next to a residential house. You're allowed to do that. But Houston does do other things. For example, you have minimum lot sizes. You have minimum lot sizes, right? Lots have to be a certain size. And the effect of that is you spread things out. Streets have to be a certain width, very wide to accommodate all the cars you need because places are so far apart. So when you have very big lots and very wide streets, you have very little walking space. Okay. You also have rules to reflect the fact that you have lots of cars, parking spots. Maybe you didn't know this. Apartment buildings are required to have a certain number of parking spots for each unit. There's always a lot of parking, right? That's by statute, right? You need to have that. The other big issue in Houston is what are called the deed restrictions. You always see driving around, this is a deed restricted community. You've seen these signs, right? Houston has very effective covenants, restrictive covenants on subdivisions. And what's unique about Houston is the city attorney can enforce a covenant. So even if the owners, that is the owner of the dominant estate, will not enforce the covenant, the city will come in and do it. Right? Also, they enforce nuisance law very vigorously. Look at Ashby High Rise. So even though we don't have a zoning code in the strict sense of the word, we have a lot of things that resemble a zoning code. But still in Houston, you will see a mall next door to a residential area, next door to a gas station, all in the same block. Right? You'll not see that anywhere else in the country, just about. Right? I love the gallery because I just walk around. Stuff is shut down now. There's more stuff that they moved, but stuff there used to be very, very useful. Illustrate at this point. All right, questions about Houston? I used to do an entire class on Houston zoning, but I just don't have time for it anymore. There's too much stuff to cover. All right, so let's go back to our good friends in Euclid. So again, you have this diagram. Jacob, why on earth would the government do this? Take a single plot of land between a railroad and a busy highway, make the stuff in front of the highway 2-family houses, make the stuff in the back end whatever, undesirable, sewage, industrial, and then this little bitty sliver in the middle where you can have an apartment building, where you probably can't even fit an apartment building. I mean, what on earth was the government thinking here, Jacob?
I have no clue. Like, I think they were thinking like it's useless. Like, I don't know that it's no importance.
You can't do anything.
Yeah, you like
Right. I mean,
so much.
wasted space. Yeah. Yeah. Ben?
Maybe like a buffer zone,
A buffer zone between what and what?
like between like a residential houses and so on, one's like 826.
So, I mean, are you going to put a 2-family house next to like a factory, like 5 feet away? I'm not exaggerating a little bit, like, very that close. Think of the case of the air conditioner, right? Where you have the residential home near the AC unit in Houston, Estancias, right? That's loud, right? This little, I mean, this is not to scale. Maybe the book's diagram's a little bit better, but this little sliver is not good buffer zone. Yeah, John. Well, to Jacob's point, they basically made their lot almost worthless. Awful. Okay, I'll come back to you. That's fine. Max.
So, like earlier, you mentioned that Houston has no zoning laws. Like, you could have like a trash dump next to like a residential area.
You could.
So, like, how would that affect like if you wanted to see some nuisances like that?
Oh, you can still have a nuisance. That's why you can't always have a trash dump next to a residential area, right? But you can have a factory, perhaps that's quiet, or residential, commercial uses.
Because like in Pasadena or whatever it is, like there's like a lot of oil refineries near like
Pasadena's a different, yeah, it's very tricky out there. Paula,
Can't you build a U2 on all?
that was my next question. You stole my next question. Waffles off the hook now, right? So the only thing, say if you want to build something consistent, right? You want to use all the land for consistent usage. What could you build here, Paula?
U2?
Yes, ma'am. Top to bottom, right? You could build 2-family houses all the way up and down the slot, all the way next to the railroad. Now, Paolo, I'll ask you to follow, please. Would anyone want to buy a 2-family house right next to a railroad? Right? It was like my cousin Vinny, right? Or any other one. I mean, even in Houston, it's an issue because the trains are stopping. I didn't read about this till recently. They just stop and they block neighbors for hours at a time. You know about this? And how do you get out? And how do you get out? You stuck? You go the other way? All right, we have a guest thing about law school. So yes, go ahead.
populate the Euclid whole house for you.
How long was it there for?
During rush hour, so it's probably for like 4 5.
Oh, worst. Yeah, Hillary.
And it was a lot of traffic because they have to stop.
It's not Hillary.
No, so like, I'm from Dayton, and the way our town works.
Dayton, Ohio?
Texas.
Oh,
And
Ohio.
it counts if the bike has but there's a law that if it's stopped for more than 30 minutes, you can report it. So my town, we just do that constantly.
Do they ever get compensation?
No, but now, well, now we're building an overpass.
Oh, good.
Over the, because we.
Somewhere over the railroad.
So you can. But like,
All right. Well, very, very good. Well, I mean, so actually, once I was coming from the airport, and I made the mistake of getting off 59 by Minute Maid, and I was driving to class, and I was like, "Oh, I'm running late," and the train came. I was like, "Oh man!" And I almost came late to class. It was a 9 a.m. class. I was so mad because it was a 30-minute delay that backed up. I was like, "Oh, I have plenty of time." Then no, I don't have any time. I ran straight from the street to the classroom. All right, I did it. Yeah. You ever take a red eye straight to class? Fun. All right. So this is sort of arbitrary, and you might have learned in constitutional law there's something called the rational basis test. It asks, is this completely irrational? Does this make any sense? And the Jacobs point, welcome back. The Jacobs point, you got two potty breaks in a row. Look at this, good, all right? Sorry, potty break. I have young children. That's terrible. To this point, this seems to flunk the rational basis test. It was completely random, right? Why on earth would you make a little bitty U3 where you can't put an apartment building, and then U2 on a busy street next to U6? It doesn't make any sense. And it diminishes the value of the property substantially by almost from 10,000 an acre to 2,500 per acre, right? Now, Waf, I'll give you the question: was this an as-applied challenge, or was this a challenge to the zoning code on its face? Which one is it? What's the difference between as-applied and facial? Did you learn that last year? It is. I'm asking you. Did you learn that in common law? If you didn't, I won't expect you to know it. Well, you're taking out difference between as applied and facial. You know the difference? Anyone know? Yeah. I don't know, whoever. Yeah. Yeah. There. Go, Julian.
So facial is like the text of the law itself. The issue and then as applied is like by following the statute, it causes all of these.
Very close. Very close.
So as applied is how the statute is being
Correct. Okay. Good. Right. So this was a facial challenge to the Euclid zoning code, right? That the way they divide up U1, U2, U3, U6, and so on is unconstitutional. This case did not concern this insane diagram on the railroad, right? So the court even says it's possible that this particular zoning code may be irrational, right? It'll come back to us later. But this case only concerned in the abstract. Can a city have U1, U3, U6? Can they have the different height districts? Can they have the different area districts and so on? Okay. Everyone get the difference? If you're curious, I actually have pictures of the lot. I don't know if I put them up here. I can't remember. But I have pictures of the lot in oh, here it is. Yeah. It's now a huge industrial park. It's all U6, whatever the numbering date, right? There's no residential there. So apparently the city recognized, whoopsie, that was a stupid thing to do. They put all commercial uses there. All right. So Hillary, walk me through, please, the court's analysis, right? On its face, was the Euclid zoning code unconstitutional?
The trial court said yes,
Okay.
and then it was reversed as they used like the fifth and 14th amendments, and they determined that it wasn't constitutional. It was good.
Say it again. I heard it wasn't. Why was it constitutional? Why did it not violate the 5th and 14th Amendments, please?
It was a case file. They said they weren't going to make like a bright line.
Okay, Realty, you want to take a step?
They said that ultimately there was nothing to restrict the city from enforcing these types of zoning rules, like, there was nothing.
Why? Why were they allowed to do it? What did the state possess here? What's that thing that they have? Police power, yes, ma'am. Right? This case is about the police power, and the court here took a very, shall we say, cynical view of apartments and city living. And I think they were sort of afraid that all the riffraff from the city would come live out by the suburbs in the village of Euclid, and that this zoning code is a way of basically keeping peace and quiet in the community. All right, so let's walk through the court's analysis. I don't mean to be cynical, but they usually don't put words into opinions like parasites, right? You don't usually see that in a judicial decision describing an apartment building, where maybe some of you have lived in various points in your life. I've lived in an apartment building, and it happens, right? So first we have the takings clause, and the other due process clause, and really they blur them together. Um, uh, it hurts my heart, but the court treats them as basically identical, so I'll just go along with it. Right? You can tell this topic grieves me much more than easements. The court held that the zoning law did not deprive Ambler of his liberty or property without due process of law. Right? Now, again, just pause briefly. What does due process of law mean? Oh, we done due process yet? What does the words due process of law? What does that even mean? You ever think about it? Someone who's not named Alex. Yeah, Alexis.
I think it's into like due process of law mostly means like the procedural rights that you have to your life, liberty, and property.
Good.
And you have to have some legal or justified reasoning to do that.
Okay, so let's say we have a murder statute, right? You're guilty or innocent. We flip a coin. We have a process. That's a process. We flip a coin. Is that due process of law? Why not? It's a process.
Not very long.
Spelled out in the statute. Statute says we flip a coin to decide guilt or innocence. Is that due process of law?
I still don't think that's a due process.
Why not? It's law. It's statute. I do an entire class on this topic. Yeah, Hillary. Yeah. Well, okay. Well, you know about the fairness, the F word, right? Why? What does fairness mean?
Fairness means they were fair.
Oh boy, Julianne. Yeah, you can say, okay, flip the coin. Is it a fair coin? Yes, you've been heard. You have a lawyer to represent you at the coin toss. A lawyer represents you at the coin toss. You know, I think with in a football game, the 50-yard line, the captains come out. You know, everyone's watching. It's a fair toss.
Does it include like other constitutional guarantees?
Like what?
That are amendment,
Which one?
fifth, sixth, eighth.
Oh, sure. Right. Fifth Amendment, due process. That we're talking about. Sixth Amendment, you have a lawyer present, right? Yeah, who else? Oh, you're right here. It's too close. I'm going to stand over here.
I think it would be adequate if that was the process due at the time, but eventually it would be.
You said something, the process that's due.
That's due to you as a citizen.
Oh, so is the due process the process that's due? You ever think about that? The process, like DUE, right? What process is due? You ever think about the words? Right? Why due process? The process that's due. And why is a process due to you? Because of law. Now, it's my good friend Alexis over here, and Caitlin didn't like my coin toss example. Just because something's in a statute book, I'm about to blow your minds. Doesn't make it law. Oh, I just blew your minds, didn't I? Just because there's some statute duly enacted with a dictator, whoever said dictator before, right? Doesn't mean it's law. That there might be some higher power above the statute. That government that acts arbitrarily, capriciously, randomly, is not actually engaging in law at all. What is law? Oh boy.
Talking about like Erie and stuff, but there's.
I am not talking about, well, you know what? Yeah.
Natural law.
Hell yeah. Well, can talk about Erie. You want to talk about Erie? Erie is an important case, not because Silver's, yes, in diversity, blah, blah, blah. No, that's not what Erie is important. It's supplanted the idea that there was a general law that goes beyond whatever courts could recognize, right? That the idea of law was bigger than what any one statute book could generalize. Right? So maybe the guy got hurt by the train, whatever. I don't even care about that, right? What is law? Law goes beyond what's in the statute books, which might lead to the topic of substantive due process, which often gets a bum rap, right? Due process speaks of process. How can there be substance? No. It's of law. And not every law, even if you're afforded a process, is actually law. Okay. Yeah, enough common law for the day. To think about it. Yeah, I do an entire. Everyone you read the story of the lottery, the short story of the lottery? Yeah. So the setup is this. I'll just summarize it briefly. You have a town. It's a fictional town, small town, and everyone draws a piece of paper from a box, and then one of the pieces of paper has a little mark on it. And there's a woman, the mother of the family, draws a piece of paper with a mark on it, and the next thing they stone her to death. I'm only exaggerating slightly. Like Caitlin, am I about? But yeah.
You're not even exaggerating.
Yeah, that's summarizing it. Cliff Note version, right? And the theory of the story is this was a fair process. Everyone drew a piece of paper at random from this box, and only one of them had a mark on it. And the town said we need to do it one sacrifice a year to help the harvest. Right, Caitlin? Am I getting that right? And there was a statute, it was in law, it was written, and that was the custom. They did every year, and everyone accepted it. And then right before the woman was stoned, Hillary, what did she say? This is not. That's exactly what she said. And as she got stoned to death.
That's the Mockingbird.
They call it Mockingbird?
Sounds like the movie The Mockingbird.
Yeah. Oh, Mockingbird. Okay. Anyway, so the point is, this concept due process of law is so significant. It has roots going back to Magna Carta in 1215. This is not modern. This is not about the Constitution or our government. It's something bigger, that there's some power greater than their own statutes, that no government can arbitrarily deprive you of certain things. Now, what those are, we can talk about for the end of time, right? So when we talk about due process, that's why I get annoyed when they say, oh, due process, taking slow, whatever, same thing. They're not the same thing. You're welcome. Yeah, sometimes I miss teaching commas, sometimes I don't. It's a hard class to teach. It's a very hard class. It is much easier. It's a piece of cake. It's my sleep. Not really. I'm not sleeping, but it's easier because I don't have to do this sort of stuff. Combo is very philosophical. It goes through a lot of really deep stuff. Maybe not in your class, but I do a lot of stuff. Anyway. Okay, can we go on? All right. So the court says that the zoning laws do not deprive Ambler of her liberty without due process of law. Right? With the presumption that this is simply just a procedural matter. The zoning code was enacted by the whatever local government officials. They followed the statute. They wrote this code, right? So they wrote the zoning code, therefore it's good. There's not much analysis. Why? Then the court says we can sustain the policy under the so-called police power for the public welfare, right? And then there's this line. A nuisance may be merely a right thing in the wrong place, like a pig in the parlor instead of the barnyard. And the pig, in this case, is the apartment complex, who is in the parlor and not in the barnyard, as it were. So it's pretty, this opinion didn't age well, as one might say. And then the court gets what you might call the tier scrutiny. And scrutiny didn't even exist at the time. So don't say rational basis. It wasn't even a thing back then. But the court exercises what you might call deference, or at least a rebuttal presumption of deference. That if the validity of the ordinance can be debated, that is, there are arguments on both sides, then we defer. Right? The legislative judgment must stand if it can be debated. Now, I think there's actually no debate. This is just completely random, right? But if we can have even a debate about whether it's good or bad, we defer. This is the Holmes dissent in Lochner, to bring it back to common law, right? If there's any reasonable debate, we should let the government prevail. And this was the sort of ethos that Justice Holmes was trying to push forward. Okay. And the court says, excuse me, we will only declare the law unconstitutional if it was clearly arbitrary, unreasonable, having no substantial relation to public health, safety, morals, or general welfare. And this is actually very similar to the language in Holmes' dissent in Harlan. Holmes' dissent in Lochner. Okay. The court also said there are reasons for this, right? It will reduce traffic accidents, reduce traffic, will increase safety and security with fewer people living there. They describe apartment complexes as parasites, my goodness, that take advantage of open spaces and attractive surroundings. In the end, this was about exercise of authority. In theory, at least, the parties can come back later and say, well, as applied, this one's unconstitutional. But they didn't need to reach it here. Max?
So like that last case we read about all those justices having like racially restricted covenants on their properties. If we went back and looked at these justices like properties and saw like their types of deeds and like the restrictions on them, do you think that it could have been different? Like if they're like, oh yeah, I don't want apartments near my neighborhood or something.
They lived in Washington, D.C., at least a couple of them lived in apartments. I know they lived in boarding houses often. So I don't know. It's a good guess. The justices didn't make very much money. And back then they couldn't get these multi-million-dollar book deals. Right. Basically now if you're Supreme Court justice, you have a signing bonus, right? You get a book deal. Right. It's like an NIL deal, I suppose, right? Never read a book before, but now you get millions of books. Go figure. But back then a lot of them actually lived in apartments, so I don't know. I remember. I don't know where Taft lived. We actually have the addresses of most of the justices at the time. I can look it up later. I'm not sure, but a lot of them lived in townhouses or apartments in Washington. Questions? Any questions on the case? None? Yeah, Hillary.
But they kind of focus. If you like, that's not good. They talk mostly about the process. And you just kind of go to the demo.
Yeah, it's mostly a 14th Amendment case. In fact, most of the cases here that we talk about are actually 14th Amendment cases. It's very rare that we have a case involving the federal government, which would actually implicate the Fifth Amendment directly. So I think almost every case we study this semester is a 14th Amendment case. All right, any questions in the case? None? I can move on. All right. So there are a lot of notes after the case, and you should probably read them. I don't always say that, but you probably should. There's some useful material there. There's something called a State Zoning Enabling Act. The State Zoning Enabling Act. What is the State Zoning Enabling Act? It is the law the state adopts that delegates to a local city or county or town the power to zone. Again, the city of Houston exists only for the grace of the state of Texas, right? Tomorrow, Texas could abolish Houston. Adios, right? Just go away. You don't have to have it anymore. But the state gives power to the cities and counties to restrict height, size, use, and so on. And these enabling acts create these various mini governments or quasi governments, right? So there must be a planning commission, right? A board of zoning appeals. There must be a way of getting exemptions from the zoning code, a way for granting variances from the zoning code, right? There are very elaborate processes that are built up to decide whether how zoning laws are enforced. In our next class, we will discuss cases in which cities and towns go too far. They go beyond the scope of the zoning law, and they can't do that. A local government, a city or town, cannot exceed the scope of a state law. The same way that a state cannot exceed federal law, preemption, a city cannot exceed state law. That's called preemption, right? Another phrase you might hear is ultra virus. Heard this phrase before? Ultra virus, V-I-R-E-S. Not like virus you get like a cold, but ultra virus, V-I-R-E-S. Ultra virus means a city goes beyond the scope of its delegated authority, and you cannot do that. The cities can only exercise the authority that is delegated to them. Fernando?
I have a question related to Hillary, with like the 14th Amendment, and Fifth Amendment, and federal government. would there be instances where the would come into play, for example, border wall, state,
I'm sorry, ask the question one more time, please.
Regarding the 14th Amendment, regarding the cases that we're gonna cover, with the 5th Amendment come into play with regard to like border states.
Oh yeah, yeah. The federal government seized land through eminent domain to build the border wall along the south. Absolutely, right. If they want to build the wall, who's going to pay for it? Well, the government's going to pay for at least the property they seize. Sorry, it's too soon. Maybe I don't know. Teaching common law from 2017 to 2020 was actually a lot of fun. It was every day like, here's a new thing, and impeachment again. Just it was sort of over and over again, right? It's calmer now. It's quiet. It's easier. Easier to teach at least. Okay. All right. So we talked about the zoning enabling acts. The next thing I want to mention is the so-called comprehensive plan, right? In theory, at least, zoning is not going to be random, right? They can't just say, we're going to zone this block like this block like this, and we'll flip a coin at that block. There's actually some sort of cohesive plan, what's called a comprehensive plan, that explains what they're doing in the big picture, right? There's a reason why we're making this area residential, a reason why we're making this area industrial, and so on. But the fact of the matter is, comprehensive plans are not usually very comprehensive. They're not usually even plans, right? They're kind of just random. So it's this sort of this deference that we get from Village of Euclid that exists to this day, where the communities are not always doing everything they're supposed to be doing. Okay. What else? Questions? Yes, Lori.
The plan, it includes like school zoning.
Yes.
All of that.
Where schools go, where parks go, where highways go. It's supposed to be a way to, in other words, if the courts are deferring to the government of how they draw these lines, the government should have some explanation of why they're drawing those lines. It must just be not arbitrary or random, but part of some bigger master plan. That's not really a zoning decision. I mean, it's funny. Use the word zoning of what school you're zoned for, but that's not land use zoning. It's a different use of the word zone. I know what you're doing. Right? The word zoning means a little bit different in that context. School's complicated because you have the different school districts and overlapping jurisdictions. Yes, Alex.
It seems to me like the majority of changes in zoning want to come via like voting in your city officials or the people that are in charge of drawing.
Well, the people on the zoning commissions are not voted on. They're appointed usually by the mayor and otherwise.
Well, I mean, but regardless, you have an indirect ability to do that through your vote. Like, I guess my question is like, what's the purpose of sort of the legal challenges to voting?
Well, so first off, just because the people who vote in your community do something doesn't mean they're respecting the Constitution, right? So I think if you ask Ambler Realty, say, yes, we elected a bunch of people who are violating the Constitution, right? The second answer is you don't actually vote for the zoning boards. They're usually appointed. So there's actually a double layer of insulation. Even if you vote against the mayor, those people still serve out their terms, and it's going to be very hard to remove them. Like with any administrative agency, it's democratic accountability doesn't always flow naturally from appointed officials who are served through insulation. If you remember, like Sela Law or Humphrey's Executor, these cases where these people have sort of independence in terms of office, there's a reduction in accountability.
Or zoning maps like on public record, and how do you ask?
Well, Houston, you're not going to because no such map exists. But in any other city, if you Google, I don't know, Dallas zoning map or Austin zoning map, you'll find it. Yeah, most cities have what they call planning commissions and board of zoning appeals. Anyone, Ryan, you done with those?
So you're going to Austin has ordinance downtown that has buildings can't block the view of the Capitol. Which is the height one, and then I mean, everything is getting so mixed use in Austin now because everybody wants to put a commercial space on the bottom of the giant.
That's the trend. Yeah, the trend which Ashby was ahead of was to have the first floor be commercial and the higher floors be residential. And that's often viewed as like the ideal because you get the best of both worlds. No? You don't like it? Tell us why. Tell us. No, I don't know. Maybe I'm wrong. What about, you don't like it?
No.
Okay. All right. What else? All right, let me wrap up and you guys can get out of here a little bit earlier today. When you're thinking about these zoning cases, you have to you don't have to think about the philosophy of what is law, even if you want to. You don't have to. But always keep in mind, is this regulation an exercise of the police power? If so, there's no need to pay compensation. But if this regulation is an exercise of the taking power, that you're taking property, you have to pay compensation. Always keep in mind, is some regulation within the scope of the Zoning Enabling Act? If so, you're fine. But if the local municipality goes beyond the scope of the Zoning Enabling Act, you have ultra vires illegal action. All right, good. All right, please put your thoughts on the feedback, the poll question. I'll be at my office if you want to come talk to me. Otherwise, I'll see you all on Tuesday. Have a very nice weekend.